Good afternoon. My name is Becky Young, and I manage the business immigration practice at Grossman, Young and Hammond, a boutique immigration law firm in the Washington, D.C. area. And I'm here with Mary Pivec, who is of counsel to our firm and a guru in all things relating to employer compliance and immigration. There was a lot of immigration news that came out on Friday evening, and one of the lesser known pieces of news relates to something called Project Firewall. Mary, what is the Department of Labor's Project Firewall initiative, and why is it significant for employers in the H-1B program?
Project Firewall appears to be or complement the President's initiative of America First, putting American workers first, and in particular, American workers in the high-tech sector. There has been a lot of dissatisfaction with the use of the H-1B visa to the detriment or alleged detriment of American workers seeking jobs in the tech industry. The Labor Department has the authority under the LCA provisions of the Immigration and Nationality Act to investigate complaints of noncompliance with the LCA attestation provisions. We haven't seen a lot of that activity over the last 4 or 5 years, and that's because there was a piece of litigation, Greater Missouri Healthcare, that limited the Labor Department's ability to investigate beyond the 4 corners of a complaint lodged by a particular individual. What Project Firewall portends to do is to give the Secretary the authority to certify a wall-to-wall compliance investigation of an employer that uses the H-1B program to determine whether they are in compliance with all of the LCA provisions and whether or not they are using the program to the detriment of U.S. workers in terms of their wages, working conditions, and ability to be hired.
So how might Project Firewall specifically impact employers, particularly those who have received complaints from U.S. technology workers?
Well, those technology workers may already have gone to the Office of Immigrant and Employee Rights at the Department of Justice, part of the Civil Rights Division there. And the employer would know because IER would give them notice that it has launched an investigation. Project Firewall specifically notes that it can obtain referrals from the Justice Department individual employee rights section regarding alleged discrimination in the hire of U.S. workers to the detriment of H-1B workers to the detriment of U.S. workers. The Secretary could use that information to direct the administrator of the Wage and Hour Division to conduct an investigation to determine whether or not the employer is in compliance with the LCA provisions, which include notice posting. Many H-1B workers work at third-party work sites. And with respect to those work sites, there is supposed to be a hard copy posting at 2 different locations at that work site to put individuals on notice that H-1B workers will be working there at some future date and what their wages and working conditions will be. They can achieve this by an alternative means, and that is to use the host employer's intranet system job board to post the LCA notice. Unfortunately, through experience, this is not being followed in many respects. Employers are relying exclusively upon electronic postings on their own websites to allegedly put U.S. workers on notice of the availability of jobs. I think that's going to be one of the first avenues of attack that the Labor Department will go after employers for, not properly posting the jobs in the first instance. And that, of course, could result in potential injury to U.S. workers who allege that they would have applied but for the fact that they weren't given adequate notice at the time of the posting.
Are there any external factors or organizations that are contributing to these challenges for H-1B employers under Project Firewall?
Well, many employers in the H-1B program have been receiving emails from disgruntled U.S. High-tech workers saying that they were interested in a particular job that was posted to the Office of Foreign Labor Certification website at the time that the LCA was filed. In most cases, these LCAs are months old. The H-1 beneficiary has already been approved by USCIS and may already be in the job. So employers are having to respond to those inquiries. Our recommendation has been that they accept the individual's resume and tell them that if an opportunity becomes available for them in their future job opportunities, that they will consider them for that job and give them an opportunity to respond. I think ignoring them is problematic, but the organization behind this, it's called guestworkervisas.com. We don't know who is funding the website. We don't know who is funding those operations, but there are plenty of enemies of the H-1B program out there, and we suspect that they have a hand in promoting this campaign.
Thanks, Mary. Let's talk about an LCA compliance investigation. So in order to initiate an LCA compliance investigation, doesn't the Labor Department need to have received a complaint by or on behalf of an individual claiming an injury as a result of an employer violation of the LCA attestation requirements?
Well, for the last 25 plus 35 years that the LCA program has been, it was adopted in 1990 under the Immigration Reform Act of 1990. It has always been a complaint-driven system by an aggrieved individual or an organization filing on behalf of an aggrieved individual. There is an alternative procedure in the regulations by which a person other than an aggrieved individual can bring alleged violations to the attention of the Wage and Hour Administrator, and the Wage and Hour Administrator can do a brief investigation and forward it on to the Secretary for certification of an investigation. They've never used this particular provision in the regulations before, but the Secretary, through this Project Firewall, is indicating that she intends to use it and wants the administrator to push forward request for broad compliance investigations to her, which she will certify. This will overcome the problem they had in Greater Missouri healthcare, because they could, from the get-go, pursue the broader investigation. The standard for issuing that broader investigation is reasonable suspicion, reasonable cause. That is not probable cause. It's a very low standard of proof, and the employer will not know who is making the allegations to the Wage and Hour Administrator. They will remain anonymous, nor are they privy to the information which gives rise to the reasonable cause determination. So in for a dime, in for a dollar. Once this investigation starts, the employer is pretty much along for the ride and hopefully is fully prepared for a broad-based investigation of their compliance program.
What categories of employers could be at risk of investigation under Project Firewall?
Well, certainly, we believe the target to be in the Indian software companies, because they are using a great many of the H-1B numbers that are available, both for advanced degree professionals as well as degreed professionals in the tech industry. And they're employing them directly and referring them out to American business in every sector, in the retail sector, in banking, in finance, in accounting, you name it. But there are also American companies who use large numbers of H-1B workers. And among those who are at the top of the list, Amazon, Google, Meta, these are Intel. These are companies that have been highly dependent upon H-1B workers in the past. And of course, they have overseas operations and that are integrated with their US operations. And they are bringing people from abroad who have worked in their organizations abroad in the H-1B program into the United States to continue developing programs that might have been initiated from abroad. We think those are going to be the primary targets, but not limited to them, because let's face it, once this gets going, disgruntled workers who haven't been hired, let us say they haven't been hired at Target, and I'm just picking that name out of the blue. Target is another user of the H-1B program directly and indirectly. They could complain, if they have identified through this job board that's being posted by guestworkervisas.com opportunities that exist at a Target headquarters facility, and we now know that the target employer, the third-party employer's address and name are typically in the LCA document. So there you can identify the target employer that you want and bring an allegation to the Labor Department that they were squeezed out of a job opportunity by H-1B workers that were being sponsored by Target directly or through a staffing company. God forbid there should have been a layoff in any company where U.S. workers were laid off in the tech industry and H-1B contractors came in their place. That would be another area that would be ripe for investigation by the Labor Department.
Mary, how can employers best prepare for a possible investigation?
Well, at this juncture, if they have not done an internal privileged LCA compliance audit in the recent past, they need to commission one now.
Agreed.
And it needs to be broad-based. It needs to go explore compliance with all of the attestations, all four of them. Obviously, posting is very important. Another important one is wages. Critics of the program, including the Heritage Foundation, issued a report within the last 6 weeks claiming that the overwhelming majority of H-1B tech jobs are now in level two of the prevailing wage program. We know that's 35% of the area prevailing wage. And typically that means that the person has less than 2 years of experience in the job. Well, there are a great many American workers with less than 2 years of experience in the job, more than entry level, but less than 4 years, who would like to be considered for those jobs. And there's going to be a question as to whether or not the people who are being hired in those level two wages are being underpaid for the work that they are doing. The argument is that they're really taking people with many years of experience and scheduling them in at level two. They're able to do that to the detriment, but not only of more junior H-1B American tech workers, but also more senior tech workers who are arguably earning high six figures for their jobs, but are edged out by someone who is being paid far less than they would be paid for comparable work. It's called leveling. And the Secretary of Labor has indicated that they're going to be looking at whether or not the prevailing wage determination and the occupational that was selected by the employer at the time that the LCA was prepared is an accurate reflection of the individual's educational credentials and their experience in the workplace and the job that they are doing. They have the authority in the course of an investigation to re-level that job, creating a large back pay liability for the employer if they are found to have been underpaying and misrepresenting what the person should have been paid for that work in their organization.
Mary, let's talk about fines. If the Wage and Hour Division determines that an employer has violated the attestation provisions, how significant are the penalties, the potential penalties?
Well, the first level violations, and this is on a per capita basis, so it's not a one-time fine. Let's say you have an organization with 100 H-1B workers, and they determine that you misrepresented the appropriate wage level 100 times. The fine for that, even if non-willful, is $1,811. That's the maximum. There's a range, and that's the top of the range. The greater the number of violations, the more likely it is that they're going to charge at or near the top of the range. If they find there is a willful violation, and generally that means that the Labor Department is coming back a second time, has warned the employer, maybe no fine the first time, warned the employer that it needs to adjust its program to come into compliance. The employer fails to do so or falls back and begins repeating a prior violation. Then the fine level goes up to a maximum of $7,370 per violation. These fines can be very, very significant, and they're typically married with wage assessments, back wage assessments, to compensate either H-1B workers who have been injured by the practice, or in the event of a U.S. worker who was denied employment and should have been hired instead of the H-1B worker, the back pay assessment could be very, very substantial. There is a 1-year limitation on how far they can go back, but nevertheless, the larger the program, the greater the exposure for the employer. And they need a professional audit to come in and give them an appraisal about where they stand in the scheme of things and what they should do in advance of an audit in order to come into compliance and with the expectations of the Trump administration.
Thanks, Mary. I have one last question for you today, which is about the investigative resources that the Labor Secretary will have in executing this Project Firewall, other than the wage and hour division. Can you speak to that?
Yeah, obviously, the Office of Inspector General has been used in the past to supplement the wage and hour division, particularly where they're going after potential criminal penalties from the employer. And I've been party to some of those the defense of those types of investigations. But here they're also going to be using EEOC investigators, lawyers from the Department of Justice, personnel from the Office of Foreign Labor Certification, and I don't know where they're going to get them because they've been laid off too. And there's a big reduction in the headcount for wage and hour investigators. So for employers who are thinking, oh, there's no way they can execute on this, they will have the ability to go to third parties. They could also potentially use personnel from U.S. Immigration Services, not ICE, but the USCIS, to investigate alleged violations of the LCA requirements. The FD&S investigators are well positioned to do that.
Thanks, Mary. We really appreciate you sharing your understanding of Project Firewall with us. As I said, a lot of immigration news has come out in the past few days, but this is a really important one for employers, and we hope that you have found it useful. Thanks so much for joining us.